there's been a small debate about what happened in court concerning the case of Mr. Speaker, sir. Of course, there's also a little confusion about the release of Mr. Speaker, sir. And some people think that he was released on a bond of 100,000 Kenya shillings. As a matter of clarification, I want to inform Kenyans that he was released on a personal bond of 100,000 Kenya shillings. Means that he was released on a free bond without paying anything. Then there was a small debate, of course, from certain quarters that why did BABU OWINO have to give evidence from the bar, and that I testified that I didn't see Mr. Speaker in Parliament. Indeed, I did see him in Parliament, and I was in Parliament. So, and I believe that you also didn't see him in Parliament. Why? Because you learnt about him on the screens, on social media, and that can be AI generated, or we know at best what happens. Even DCI officers will come up with different issues, but be that as it may, the main issue that we want to talk about here now is the slight debate that, as an advocate, why did BABU OWINO go out of his way to probably act as a witness? And I want to tell you that there's a simple answer to that. First of all, when I talked in court, I did inform the magistrate, and I quote verbatim, that at a particular time, I may be forced to be a witness on the defense side. That was so clear. So when you leave something and you leave the main, you know, these two could not, each cannot exist individually. You cannot start claiming that BABU OWINO just said this without taking a full statement that he said. So I was very clear, and the magistrate also agreed with it. I was clear that at a particular point, I may be forced to be a witness for the defense. With that alone, you ought to have stopped your debate in that particular moment. So when I said that I saw him, I'd already qualified my statement before the magistrate. And therefore, even if, assuming that now I didn't say that statement, that I didn't tell the magistrate that I may be forced to be a witness at a particular point for the defense, assuming that I just said that I saw Mr. Speaker in Parliament and left it at that. Now that is where certain quarters, some people with some little knowledge from certain quarters, they are coming up and saying that BABU, you ought not to have said that. I want to talk now as a law scholar, as a person who is studying here, and I want to really bring this from far about law and morality. And in law and morality, we have different schools of thought. In jurisprudence, we have the positivist law theorists. Those are people who basically believed that the only law that existed were written laws. That if there was no written law, then there was no any law. And that law should not have any aspect of impurity in it. And that laws should not be associated with morality. That is, the natural law theorists believed so. And that is where some of these people who are debating now belong. And that they believe that because I'm an advocate, I should not testify from the bar. I should not talk in support of my client, or rather act as a witness, as I represent my client at the same time, and that is provided for in the advocates' practice rules. Rule number 8. Rule number 8 clearly states that an advocate acting as such should not represent a client if it is believed that this advocate may at one point be a potential witness to the same case. So I want us to dissect and come back to this, and I want you to follow me clearly. So I've talked about the natural law theorists that believe that law can only be written laws. And the people who talked about the natural law are, number one, we have Professor H.L.A. Hart. We have Hans Kelsen, who also opined about the natural law theory. On the other hand, we have not natural law theory, but positivists. On the other hand, we have the natural law theory, and the natural law theorists that we had among them were, number one, Professor Lon Fuller. Number two, we had St. Thomas Aquinas. Number three, we had St. Augustine of Hippo. These are some of the proponents of this natural law theory. St. Thomas Aquinas believed that unjust laws are not laws at all, should not be laws. Unjust laws should not be obeyed. He's the same person who talks about, in no specific order, talks about and believed in lex eterna, which is the eternal law. Lex means law. Talks about lex naturalis, which are the natural laws. Third, he talked about lex divina, which are divine laws. And lastly, lex humana, which are the laws written by human beings. That is the positive laws. And he believed that as long as the laws written by human beings are not conforming with the natural laws, then that law is unjust law, and that law should not exist. That law should be disobeyed. And this brought a very big debate between two gentlemen, Lon Fuller and H.L.A. Hart. When they came together, they were debating. And the issue of German Holocaust came. So Lon Fuller asked H.L.A. Hart that you believe that only written laws are laws, and then there should be no impunity. Nothing should interfere with those written laws. And he said that, okay, in German, there were written laws that the Jew was supposed to be killed. And number two, that any Jew was not supposed to be helped. Even if you found a Jew dying, then a Jew was not to be helped. Even if it was a child, a woman, mother, or anybody, then that Jew was not supposed to be helped, was supposed to be left to die. Then those are written laws. Those were written laws then. Then Fuller asked H.L.A. Hart that indeed those written laws existed, we agree. But do you think they were good laws? That if you found a Jew, kill the Jew. And if you found a Jew dying or in need of help, you should not help that Jew. Were they just laws? That is the point that H.L.A. Hart said that indeed it was unfair, and that indeed those laws, it was immoral as much as those laws were legal, but it was immoral to kill the Jew. And at that particular moment, Professor H.L.A. Hart changed his heart and recognized the natural law theory. And indeed he said that as much as these written laws exist, there should be some element of morality. Elements of morality in these written laws. And that is where now I'm coming in relation to what we did in court the other day. As an advocate, there are written laws. So in relation to law and morality, we say that something illegal is not necessarily immoral. And something legal is not necessarily moral. For example, to those smoking cigarette is allowed, you can smoke cigarette. To those smoking it, the fact that cigarette is allowed to be smoked, that is illegal. There's legality in it that is allowed, that you are allowed to smoke cigarette. But to some people, it is an immoral behavior. So something legal is not necessarily moral. But when we talk about something illegal is not necessarily immoral. So, assuming that I didn't address the magistrate, that I could at some particular point act as a witness in that same case of Mr. Speaker, sir. Then, what I did was to defend my client in court. It could have been illegal, prohibited by the advocates' practice rules. It could have been illegal. But it was moral for me to save my client, to help my client, Mr. Speaker, sir, Mr. Ezekiel Cham. It was moral to help him so that the court could not deny him bail. So I think that for those who are the naysayers, those who are bringing up the debate about this thing, I think you need to really go deep and do serious research before you just talk. Otherwise, thank you.